Hello friends, Namaskar. How are you? Today I am going to discuss an important problem concerning prevention of corruption. The topic is connected with section 13 subclause 1 subclause D of PC Act along with section 420 of IPC. And when both the sections are imposed on the public servant, a panic scenario occurs. On the one hand, he has to face the criminal charges. On the other hand, the department may initiate the departmental proceeding on ground of misconduct. So whenever we are having such type of FIR, what to do and how to protect ourselves from the same are the important points for discussion. I am going to discuss one of the most important case of Honorable Madhya Pradesh High Court on the sad problem, and ultimately I will also discuss the solution as well. For this, I request all of you to please maintain the data in your notebook with the help of pen or pencil so that whenever you are having the sad scenario, you could easily encounter the problem without getting any further panic. At the inception, we will note down the concerned sections that might affect the services of a public servant. Sections are 13 subclause 1 subclause D of PC Act, section 420 of IPC. As far as general idea is concerned, in legal protocol is concerned, section 13 subclause 1 subclause D of PC Act is applicable only on a public servant. If you are not a public servant, then there is no need to worry. Apart from that, it is not concerned with trap proceeding. It is concerned with criminal misconduct, wherein there is no demand, recovery, acceptance, but allegation is of criminal misconduct. Means the concerned public servant by misusing the official position inter alia for pecuniary benefit, either for himself or for any other person in whom he is interested, provided undue benefit to a person which is not within eligibility of said person. So by the said practice, he entirely giving the wrongful benefit to that person. That is called the case of criminal misconduct. Please note down the same. And as far as section 420 of IPC is concerned, it is basically the aggravated form of cheating. It says whoever cheat and while acting deliberately or fraudulently deceive the person, and in consequence of deceiveness, the person who is deceived entirely part with a valuable security or anything that will be converted into a valuable security. In that scenario, the person doing the same is said to be guilty as per section 420 of IPC. Now it is clear to us that if both the sections are on record, then prosecution must satisfy that we have abused our official function. While doing the same, we entirely provided undue benefit, and we have done the same for pecuniary benefit for ourselves or for any person in whom we are interested. If the elements are absent in that scenario, prosecution would fail. Please be noted. And apart from that, there is no presumption of section 20 of PCA, as we observed in case of section 7 or 11. So whenever we are having a charge of section 13 subclause 1 subclause D of PCA, it is duty of prosecution to prove the case beyond reasonable doubt. If the prosecution totally failed regarding the same, in that scenario, we can claim the immunity. And beyond reasonable doubt means they are required to put in the circumstances and facts on the point of consistency and corroboration. If the facts are inconsistent, and apart from that, the allegations are general, omnibus, and the cycle is not complete, in that scenario, on point of irrelevant fact, general allegation, mere surmises, and conjecture, we may challenge the proceedings as well. Now, we will note down the problem. The problem is concerned with appointment. Sometime due to our education, we may be the part and parcel of the appointment process, and inter alia be the part of a selection process. When we inter alia select certain persons, the persons who are not selected may raise questions on the process of appointment. Inter alia, there might be a media publication or matter could be taken up by CBI Vigilance or Anti-Corruption Bureau. When all such scenarios are occurred in that scenario, we might have to face a great peril. Because due to media publication, we have to face loss of grace. And due to a criminal case, we have to face the criminal charges on wrong basis. And apart from that, we have to face departmental action if initiated accordingly. So we have to work out on each and every fact so that we could understand the proper solution and could get a proper remedy. So the problem is, suppose Mr. A is part and parcel of a selection process. Ultimately, there is an allegation that he has selected those who are ineligible, and inter alia the selection process is affected, department is defined, the proceedings are liable to be initiated as per section 13(d) of PCA with section 420 of IPC. Now the important question arises, what Mr. A can do? If he wants to fight legally, he must be equipped with the legal knowledge, must be equipped with the protocol so that he could contest the case without anybody. Regarding the said problem, the solution is given by Honorable Madhya Pradesh High Court in a case titled as Shri DP Singh versus State of Madhya Pradesh. Judgment is dated 25th of June 2025. In the said case, while assailing the entire proceeding, it is contended on behalf of accused person that no offence is committed. Entire allegations are general, omnibus, and apart from that, there is nothing on the record to show that what illegalities are committed by the accused person in the appointment process. Because when an act is done with intention to have the deliberate gain, in that scenario, the facts, circumstances must be on record, duly supported by evidences. No case can be allowed to run without a proper evidence. In the present case at hand, the defense attacked that there is nothing on the record to suggest what illegal means are adopted by the concerned accused persons to discard the selection of eligible students. And apart from that, those who are eligible had not raised any complaint or objection regarding the same. And apart from that, there is nothing on the record to show whether the marks of ineligible students are manipulated or enhanced. On the contrary, the marks of eligible students are decreased or manipulated just to cause them a wrongful loss. Okay, now. So, in that scenario, when such of allegations are not on the record, allegations are general, it could not be said that the concerned accused persons are having any ill intention to have wrongful gains to those who are not eligible or wrongful loss to those who are also not eligible for the same. So, while contesting such type of cases, the following are the key points. We should attack on the nature of material. If the facts are on record and facts are not consistent, there is no corroboration. In that scenario, the evidences cannot be said to be relevant. If the relevant material is not on the record, every fact is independent. In that scenario, the prosecution loses its strength and we could have the benefit. Apart from that, we have to see the nature of allegation. If the allegations are general omnibus, then we could take the stand that mere surmises and conjecture cannot be a basis for prosecution. Apart from that, we have to see the nature of complaint. If the allegations are not specific or general, we could have the benefit. And apart from that, who has come forward to sustain evidences against us? If the concerned students who are not eligible are selected, and apart from that, the persons who are eligible, despite of that, are not selected, but they never come forward to make the report, even in the court, they never turned up in the witness box. In that scenario, it could not be said that the allegations are duly proved against us regarding the appointment scheme. In said case, the concerned accused persons are discharged by the Honorable Court on ground that allegations are not specific. If allegations are not specific, cases running on mere surmises and conjecture, in that scenario, prosecution vitiates and proceedings are abuse of process. So looking to the facts and circumstances, the proceedings are set aside and quest. The judgment is beneficial for us. Inter alia, it causes us to learn the five important points. Number one, whenever we are having a case regarding the appointment scam and case is registered as per section 13(1)(d) of PC Act with section 420 IPC, no need to be proceed in rush. Wait and watch. And apart from that, there is no need to move for anticipatory question. We have to read the FIR and have to submit the representation. Number two, while making the representation, just read the entire FIR and find out what allegations are true and what allegations are false. And we have to give our reply on the theory of probable defense, just to create possibilities of implications in the case. Number three, we have to specify in our representation that the concerned agency totally failed to investigate the case in the right perspective. They have done the investigation as per their own whims and discretion. But the key point is that they have to apply the protocol of legal compliances to find out whether a prima facie case is made out against us or not. If the allegations are not specific, allegations are general, then we could have the benefit. Number four, the submissions are to be given to the higher authorities so that they could mark their subordinate for the proper investigation. In case, despite our direction, the case is not investigated, we can take the shelter of unfair investigation. Last but not least, we have to observe the quality of allegation, we have to see our specific role, and apart from that, what are the specific allegations against us. If all the answers are in negative, then we may also plead the same in our petition as a point of defense. So these are the important guidelines and tips for all of you while contesting such type of cases. So I think that I am totally able to cause all of you to understand this topic in a very easy manner. So see you in the next video. Till then, Jai Hind, Jai Bharat.